There comes a point in everybody's life when it's time to get your affairs in order. In this particular episode of The Village Local, we're going to be talking about wills and estate planning. In particular, we're going to be covering how to write a will and the sort of things you want to put into a will, as well as the things you may want to leave out of your will. We're going to be discussing why it's so important to have in place an enduring power of attorney. And we're also going to be discussing the idea of contesting a will and what you can do when writing a will to avoid family conflict once you've passed away. To help guide us through the answers to these questions, I'm joined by Brian Hurd, who's a leading elder care attorney in Australia. So without any further delay, let's jump into it. So as I was saying, when I reached out to you last week, it all started with somebody just simply asking, does anybody know where I can download a blank will kit that I can fill out myself? Brian, you were the first person that came to mind. So thank you for making yourself available.
That's fine. I'm happy to, because I tend to be very passionate about this area, both from professional experience, but also from personal experience, because contrary to rumour, lawyers do have parents. And as a result, I've had aging parents and have been through the personal experience of the demands and challenges of aging parents. So there's a personal element to my passion, but also I've built up a professional experience and expertise.
The key questions that the community put out in hopes to get answers to were, what is a will? Why do we need one? What is guardianship?
Yeah.
How does that relate to advanced care directives? For those that are kind of new to all of this, maybe don't even have a will in place, let's take the conversation there and let's say, all right, this is the situation. This is something that you want to consider. Let's sort of break it down from there.
So that really is talking about the common Australian cultural aversion to confronting the future and confronting unpleasant events in the future, such as death. We don't want to do that. And the consequence of that is, if you do nothing about a will, at least understand what the consequences are of doing nothing. The consequences of doing nothing is that the law says, in a fancy term, you die intestate. In other words, without a will. Now, what's the consequence of that? It's all bad news.
Hi, if you don't know who I am, my name is Jim Moratis and I run an organisation called Village Local. We help older Australians navigate their way through the complexities of the aged care system in order to enhance their independence and well-being. If you're finding value in the information that we put together and the content that we produce, then I suggest you hit that subscribe button, hit the like button, and also leave a comment with any questions that you might have, and we'd be happy to produce additional videos that address your specific needs. Thanks for watching.
The bad news is, you don't decide who gets what by doing a will. The law prescribes what happens. And the law prescribes that if you don't have a will, then if you are married or have a spouse when you die and you have children, the law says, without a will, the first $150,000 of your estate, plus what's called the household chattels, the pots, the pans, the knives, the forks, and the victor, will go to your spouse. The rest of your estate is split equally between your spouse and your children, all entitled at the same time. Now, what does that mean? That means that the spouse doesn't get everything. The spouse has to share the estate with the children. Now, you may have made a will in which you say, give everything to my spouse, no problem. But if you haven't made a will, the law says this is what happens when you die. Now, you can imagine all sorts of ugly scenarios where children are immediately entitled to a share of their, for example, their father's estate, and mum gets only a proportion of it. So they're all equally entitled to that extent. And mum's living in the family home. Those children are now part owners of that home. Now, what do you reckon the prospects are that all of them would say, Mum, you can stay there as long as you like?
Yeah.
And when you
the prospects of that are high, but I can imagine there'd be quite a few scenarios where that wouldn't be the case.
Close to zero, Jim, close to zero.
Yeah, right.
So what you start to identify is the consequence of doing nothing about a will is not only that you don't decide what happens, but what happens is you leave a legacy. And this is the most important thing about doing the will. If you're concerned about the future of your family, and some people aren't, but if you are, doing a will not only allocates what you want to go where, it also reduces the legacy prospect of implosion of your family. When you create this problem where the people become entitled to your estate that you never really wanted to be entitled to at that stage. And that leads to family dispute, disputation, legal proceedings, even where the spouse will challenge the intestacy. So you can not only challenge a will, you can challenge in a court the consequences of intestacy. So in a case like I just mentioned, it would be well advised to that spouse to challenge the consequence of intestacy as if there was a will. And that causes more disputation and, of course, legal costs. And ultimately, what happens when you don't have a will is that the major beneficiary of your estate will be lawyers. And most of us don't intend to do that because we're not a well-known charitable cause. So as a consequence, the legacy issue rises remarkably because what beneficiaries see is that lawyers extracting all this money from their mum or dad's estate. And why? Because mum or dad didn't do a will.
Got it.
That's all.
Got it.
It's all about, if you're looking down from heaven, what do you want to see?
Mhm.
You want to see imploded families in courts of law where relationships come to an end, siblings fire up and arc up, don't talk to each other anymore. And the source of the problem is not the siblings, it's the mum or dad.
Sure.
Because they did nothing.
So to tail this part of the conversation off, for those that have an intent to leave a non-imploding legacy but don't have a will in place,
Yep.
What's the next step for them?
The next step is to do what some people do these days, which is very trendy, is to record your will on your mobile phone.
Okay.
Or text yourself a will.
Okay.
The problem with that is that it's only doing half the job, because the problem with that is the law will not regard those devices or that piece of paper on the face of it as a valid will without going to court for a court to declare that is a valid will.
Got it. All right.
Whereas if you had an actual valid, proper will, you wouldn't have to take it to court for the court to say that's a valid will.
Okay.
So it's all very well to be creative.
Okay.
But in the end, again, you're leaving a legacy of legal proceeding.
Sure.
The other thing you can do is you can go and DIY it online. Now, you might be surprised to hear as a lawyer, I don't recommend that. Not out of self-interest, but again, out of caring to make sure that you've done, firstly, a valid will, and secondly, that it actually reflects what you want. Because as you can imagine, we sometimes see do-it-yourself wills, and we see problems with them, lots of problems. Because even though they come with a set of instructions, people find it difficult to follow the instructions.
Sure. So,
for example, recently I had a client who came in with it very proudly showing me his DIY will, which he had signed, and he had his brother as one of the witnesses. Now, that brother is a relation, and they should not have been a witness. So potentially, by his brother witnessing the will, that is effectively an invalid will. The other problem is the lack of sophistication in DIY wills, because most DIY wills are what we call mum and dad wills. In other words, I give everything to my loving spouse, and then I give it to my loving children. That's what most people have in their will. That could be the worst will in the world, particularly if, for example, you've got a large estate and your spouse has died, and suddenly the children become entitled. One of those children is bankrupt. Right. And as a consequence, in comes a large sum of money into their hands, and that money then is diverted immediately to the trustee in bankruptcy. In other words, that child doesn't get a cent. Okay. Or one child could be on a Centrelink pension, and suddenly in comes a large sum of money to them, and guess what? They lose their pension. Not only that, they lose all the benefits that surround the pension. Yep. So it's all very well to say you want to keep it simple and do a DIY, but just the fact of doing a will doesn't mean you've done a good will. And that's why we say going to a lawyer not only gets you to do a will, it gets you to do a good will, as opposed to a potentially bad will. Now, it's a cost-benefit decision, because a DIY is relatively cheap, and lawyers are not relatively cheap. And that's because you have to pay for a good will as opposed to a bad will. And the difference is a cost-benefit decision for a client. What I want to do, good one, bad one. Well, at least I want to do one, but what sort of will do you want to do? And are you prepared to pay money to a lawyer to do a document that doesn't benefit you? Because when the will is exposed, when you die, it does nothing for you. So a will is a document that benefits other people. So the theory is, well, why should I pay good money to a lawyer for a document that doesn't benefit me? It benefits all these other ingrates.
On that segue, let's take it to that next layer, which is the words that quite loosely get thrown around, enduring power of attorney, guardianship. Can you break that down for us? What's the difference between the two? How do they apply? What are the key factors to consider?
Well, let's just put some context here. And the context is we would never used to talk about these concepts or documents maybe 30 or 40 years ago. So what has happened in that time that I mentioned earlier is that because we're living longer, the propensity for us to lose our capacity increases. Now, the issue is then, if you do lose your capacity, who can make decisions for you? So some years ago, the lawmakers introduced the concept of an enduring power of attorney. Now, that is an adaptation of a power of attorney. So we still have powers of attorney documents where you appoint someone to make financial decisions for you if you go overseas, for example. The trouble with the power of attorney is that the law says it comes to an end if you lose your capacity,
right,
which is exactly when you want it to continue.
Yep.
So they introduced this new concept called an enduring power of attorney, which is a power of attorney that endures. In other words, it keeps going after you've lost your capacity. Now, the problem here is most people don't understand, again, what the consequence of doing nothing is. And here's the law. The law is if you do not do an enduring power of attorney, nobody in the entire world can make financial decisions for you. You are in what's called a legal black hole. Not your spouse, not your children, not your next of kin, nobody. Now, the problem with that cause is if you do lose your capacity, guess what the consequence is? You don't have an enduring power of attorney in place. Guess what happens? Somebody, could be a member of the family, has to apply to a tribunal, could be the spouse, to be appointed what's called your administrator. Now, that costs money. It also results in delay. Meanwhile, of course, there's a dispute amongst the children. Who should apply to the tribunal to be mum's or dad's administrator? So you start to see, again, the consequence of doing nothing is also an implosive consequence on families because it creates this tension, this stress that only arises simply because mum or dad didn't do something. So if you haven't done an enduring power of attorney, you're mad. Probably too late because you're mad. But if you don't have one, the consequence is you are assigning your family on the statistics, almost inevitably, to family explosion, disruption, dispute, which is not really what most parents want. So for the sake of doing a document, and I've seen a case, I had a case some years ago where legal costs were $410,000. Why is that? Because mum, who was very rich and was the sole director and shareholder of the family company, had a stroke sitting at her desk one day, sole director. And as a consequence, into hospital, vegetative state, never done an enduring power of attorney. Now remember what I said before, the consequence of not having one is that that company came to a grinding halt because no one could substitute her to be a director or a shareholder. So the consequence is off to the tribunal. Now, why is that a problem? Because she had 4 children and none of them could agree who should apply. So they all applied in competition with each other and they all had their own lawyers. So there are 8 people arrayed across the hearing room floor when they came to argue about who should be appointed. And here's the irony. The tribunal was never going to appoint any of them because there was too much disputation. So who did they appoint? That well-known benevolent bureaucrat called the public trustee.
Right.
So a bureaucrat, a benevolent bureaucrat came in to make financial decisions for the mum and in relation to the company when the 4 children had to stand on the sidelines and watch this happen. Now again, why? Because she didn't do an enduring power of attorney.
I'm going to ask this question for all those people who are going to be listening to this, sitting on the sidelines and may not be fully bought in or motivated to take action. Brian, can I ask you, what holds people back from taking action? And I know that is that's casting a very wide net. But what do you think are some of the reasons that people do not take action to get these matters sorted out?
Lots of reasons, as you can imagine, because that's the nature of human beings. We all have different motivations or lack of motivations. A lot of reasons relate to, for example, There are some people out there who simply don't know what to put in their will. In other words, they want to, but they don't because they can't work out what to say. Now, that tends to be a major problem in blended families. In other words, where you've got stepchildren, biological children, second marriage. What does each of the parties to the second marriage, what sort of will should they have? And it can be so vexing that there are some people out there who have decided to solve that problem by simply dying as much as they can with nothing. Because if you die with next to nothing, there's nothing to fight about. Now, the trouble with that is it's very hard to die with nothing. I've had clients try and do it, but you can't. You simply can't spend enough, if you're rich, for example, in order to die with nothing. So it's not a realistic solution. The other is the common psychological factor, which is most people have an aversion to talking about death, the big D. So we try and encourage them not to talk about death, but to talk about, we call it celestial transfer. And they tend to find that a softer concept.
Okay.
The mystical experience with their lawyer. Anything to get them over this hump of aversion to the fact that we have to admit that doing a will is an admission that we're mortal. And we don't want to admit that. In fact, most people are prepared to consider doing a will. What they're not prepared to consider, and when you look at the stats, they're not prepared to consider they're going to lose their capacity. They know intellectually they'll die. And converting that knowledge into motivation and then doing something, such as a will, is relatively easier than to get them to do the same process with an enduring power of attorney, because I know I will die, but I don't think I'll lose my capacity, because that'll happen to other people. It won't happen to me. So the irony is it's harder to get people to do an enduring power of attorney than it is to do a will. And the statistics show that about 46% of Australians have a will, whereas, for example, in Queensland, only about 14% have an enduring power of attorney. So that shows you the proportional, rational, irrational approach people have to losing their capacity.
So you use the word irrational there. Are you saying that those who embark on the journey of putting a will together should, by default, just tie in an enduring power of attorney to that exercise as well?
Make it a package deal. Because you deal with death and you deal with, we call it disability, but you deal with both concepts, because the reality is in later life, the future comes closer and the past gets longer. So the reality is, the older you are, the more vital these documents are, because the time to do them is reducing. So that is a motivation for some people. On the other hand, it still just adds to their aversion, because it emphasizes the fact not only are they going to die, they're going to die soon. Because when you're 23, you're not going to die for a long time. But when you're 83, the prospects increase exponentially. And that just feeds the aversion, because they get the feeling that by talking about their will, what I'm saying to them is, you're going to die soon. And as a result, we better do this now, because pestilence and damnation will follow you and your family if you don't.
Yep.
That sort of negative psychology works with some people, it doesn't work with others. We get people, for example, who get suddenly motivated to do something. They'll come in, they'll talk about it, we'll get some understanding or agreement what they want. We do it, we send it to them, and they go to sleep. In other words, they can't regenerate that motivation because they've lost interest now, the aversion takes over again, etc. So we tend to try and do these documents really quickly, because we know that life is uncertain. That's the first point. The second point is they can lose the drive to do it.
The half-life of motivation is very short in some regards.
Very short.
At Village Local, we help a lot of people navigate their way to government-funded home care services. And you can imagine the bureaucracy associated with that journey. A lot of people, they embark on that journey, start educating themselves about what's involved, start taking action. First roadblock they hit, it might be a bad experience with the contact centre My Aged Care, or an assessor that didn't fully appreciate their needs, or something like that. Hands go up, all too hard, back on the back burner. Right? Is that what you're kind of referring to there? Where there's somebody who has started that journey and then they hit a barrier, and then it's just like, put it for future Jim to deal with, or future so-and-so to deal with.
The all too hard syndrome.
Yeah.
And that's very much the case in many cases because, again, because of people's relatively complex affairs, doing a will, for example, gets harder because you've got to deal with potentially all sorts of associated issues that don't relate to a bank account and a home, such as the super, such as the family trusts, such as people who want to disinherit children. Another big trending issue. How do you do that? So these sort of new age issues, the other issue I should tell you about is what I call the Ken and Barbie syndrome.
Okay. Oh, this sounds
I don't know
good.
whether you, and this is something I never used to raise, and again, it's a reflection of longevity. Never used to raise until about 10 years ago. For example, I may have a married couple in front of me. They've been married for 60 years, and they've come in to do their will. And their will is a conventional will, everything to each other and then to the children. And then I say to them this. I said, just before you go, can I talk to you about what I call the Ken and Barbie syndrome? I say, what's that? And I say this. Let's call them Bob and Beryl. I say to Beryl, Beryl, you could die first, and Bob, you could live a long time. Because longevity means you could live a long time. You might have another 20 years, Bob, after Beryl's death. Now, what are you going to do in that 20 years, Bob? Are you going to close the front door and mope? Or are you going to go to the local RSL line dancing class where you meet a
Barbie.
So enamored by Barbie, are you? You race off to your lawyer and promptly change the will you did with Beryl that many years ago. And it works both ways, of course. I say, Bob, you die first, Beryl, you go to the same RSL line and you meet a Ken. Now, that never used to be an issue because we're talking here about very vanilla type of relationships, long married once, couples who have a simple lifestyle, simple wealth, but then comes this complexity. So we're not just talking about complex financial affairs or relationship, we're talking about simple financial affairs where lifestyle and social issues make that very simple picture very complex because of longevity. And the law lets you do things to address that. So you won't get this on a DIY will kit. In other words, the law allows you to do effectively a contract between Bob and Beryl to agree not to change their will. So they have two documents constituting their will, their wills, and a contract between them, not to change in case a Ken or a Barbie comes along later to disrupt the plans that they had 20 years ago. So that's the sort of thing that lawyers are good at, telling you these sophisticated things that you won't find on a computer program or an app.
Right.
Because apps aren't designed to tell you about, in your circumstances, you need to consider these things. What they will tell you is, here is a template conventional mum and dad will, just fill in the blanks. Now that might be all very well if it's done properly, but it won't take in the relative complexity or the subtleties even of a person's affairs or indeed their potential future, because that future can impact on the present. When you become single again in later life, everyone will become single again in later life. You won't die with your spouse on the same day. So the survivor will be single. There'll be a return to singlehood later in life. And that is a very interesting, challenging time in terms of the lifestyle you choose and the complexities that creates for your legal affairs, such as your will.
These are fascinating topics, and so much of what you said today, I thought I was roughly across it all, but there are so many gaps for me, and you certainly lit that fire for me. So hopefully the half-life of my motivation doesn't peter out.
But it will.
It will, and I've got you to lean on, right? But I do want to talk about something before we wind it up.
Yes.
You didn't ask me to do this, but I do want to raise this, right? So
yes.
You wrote this book, The Aging Parent Trap. Why did you write it? And what do you hope people will take away from this book?
Well, I wrote it motivated by the tiredness and the distress I felt about most Australians who operate and work in what's called a crisis management mode. In other words, here we have longevity again. Most siblings do not consider that their parents will either die, either lose their capacity, or indeed need to get high care residential care. They think consciously that their parents will live in their home until they die. They'll die in their bed. And nothing would have happened before that. Now, when that, of course, doesn't happen, and there is some crisis for their parents, you then have children in a crisis management mode. For example, I had a client last year who lost her capacity, who had made an enduring power of attorney, but she had appointed 3 of her children. One of them lived in Houston, Texas. The other was on an oil rig in Kazakhstan. And the other one, we call the martyr child, was living in Brisbane nearby. So now we've got the 3 of them appointed to make decisions, but none of them had discussed before this event, which was almost inevitable given mum's circumstances, what are we going to do in this scenario? In other words, one day, mum goes to hospital does everything they can for her, as it was the case here, and then says to the daughter here, we've done everything we can for her, there's nothing more we can do. She needs to leave. Oh, but by the way, she can't go back home. Mm-hmm. So suddenly, on that one day, we have what's called a family crisis. Mm-hmm. And that crisis, as you can imagine, leads to people trying to find out all sorts of pieces of information about what are options, while the 3 of them, of course, are in the disparate parts of the world. And you can imagine how efficient that decision-making process is. And you can imagine, as a consequence, the relationship between the 3 children was just poisonous after a while. And why? Because no one sat down with the 3 of them, or mum, and said, now, mum, let's plan for the future, because all the statistics are telling us that something's going to happen. Let's plan for something to happen. And the book is basically 2-pronged. One, my experience of this crisis management syndrome, what can go wrong, and why people should plan. Because unless you plan for these very, very anticipatory events, you end up in crisis. When you're up in crisis, the worst things happen. Making decisions in crises are the worst decisions you can make, and you can imagine it can have a really adverse effect on the welfare of your mum or dad, because they're now relying on you to provide them with support, care, and correct decisions in a hurry amongst people spread all over the geography of the world. So the book is meant to say, this is what could happen to your family, and this is what the solution would be in terms of planning for it now. So let's get informed up front. Let's get educated about what we can do if and when this crisis happens. Not when it happens, if and when.
There was one particular part of Avoiding the Aging Parent Trap that I want to read out. This is a book that forces us to confront what most of us avoid, planning for our aging parents. Our natural inclination is to wait and see what might happen. But when it does happen, or starts to unfold, most families are totally unprepared, and the results can be devastating. I think that sums up exactly that.
That encapsulates the book.
If there's one lasting message that you want to impart on people,
I just suggest, can I borrow the Nike phrase? The Nike phrase is just do it.
Love it. We're going to leave it at that. Thank you, Brian.
Okay, thank you, Jim.
Hey there, Jim here again. If you found that video interesting and you want to be updated as soon as we release our next one, then make sure you hit that subscribe button. That will make sure that as soon as we upload our next video, you're going to be notified. And once you've subscribed, why don't you click to the next video and you can check out more great content just like this one. See you there.